Kia ora, Mr. Barker.
I wasn't intending on taking too much of your time. I did a reasonably complete opening yesterday,
yes.
And I think that in fairness, the issues that were raised have been well canvassed during the course of this hearing. I don't see there's a great deal of point in me repeating them. So I was really just going to target a few points just of clarification on issues that arose. The other aspect is that, of course, if there's any questions from the commissioners or areas for further inquiry. My friend Ms Anderson said that since I was doing this as an oral closing after the hearing, if I needed to file anything later on, I'd be more than welcome to do so. So there may be issues that the commissioners either I cannot answer or you say I'd just like to know a bit more about that, and I'd be happy to do that. So opportunity to find those. But this is, I suppose, almost using the framework of a court process, really a little bit of a reply to some of the issues that occurred during the course of the hearing. Just coming to a few comments on the nature of the redress program, there was some comment made or criticism, I suppose, that it's been put in place before the work of the inquiry has been completed, the independent inquiry. I mean, Mr Snodgrass explained why that was, but I just wanted to draw to the Commission's attention that it is specifically addressed in the terms of reference at clause 11, where the survivor can make an application for redress prior to the inquiry being initiated. But
just to confirm, Mr. Barker, these are the terms of reference of the
Dilworth redress.
Dilworth redress
scheme. The Dilworth redress scheme. That
yes.
It allows survivors to make an application for redress, have it considered and dealt with there and then. They can make one for redress, have it held in abeyance until the inquiry is determined, or they can make one after the inquiry if they wish to do so. And it also expressly includes the ability for, if the redress panel makes the determination prior to the inquiry, they've got the ability to revisit redress awards after the inquiry has come out. So it was an attempt, as Mr Snodgrass indicated, to try and give people who wanted redress now the ability to seek that redress now, and if people wanted to seek it later, then they could seek it later. Two other points on the terms of reference for that redress program. I heard, I think one of the archbishops just make the comment that he was concerned that that program sort of ended at the decision that is reached. I just wanted to note that the definition of redress that can be given is very broad, and it allows for counselling can be set up through the redress award that's made. And also includes a very, very broad discretion for the panel members to decide what form of redress is appropriate. So the whole scheme from, I suppose, Dilworth's point of view is that it does put a lot of trust in those panel members to react to the situation of the survivor that is before them. And that's really part of the whole step that's had to be taken by Dilworth, and it's had to work its way through, is that element of letting go, that once it's established, it is out of their hands what happens and how it is dealt with. Their sole obligation is to do as they are told by that panel.
An ongoing obligation is accepted.
Yes, if the result of the redress is there should be an ongoing relationship, that is what will have to happen.
Thank you.
And then finally, just on the terms of that redress program, I just wanted to highlight there was an issue as to the interaction between these two programs, and this might be something I set out in just a written note afterwards, because it's one of those issues I saw in emails but haven't quite followed, but there was, I suppose, an interaction between the redress panel and the inquiry as to how do they deal with survivors who want to come to both of them. And I think there may have been an agreed protocol between them as to how they deal with that.
But just to be quite clear, you're talking about the Dilworth redress plan?
Yes, and the Dilworth independent inquiry. So,
right.
so you've got a situation where someone might go to the inquiry but also want to seek redress. So how do you manage that person? You don't want them to have to go and, give the same story twice.
And that raises an issue, Mr Barker, that I've had in my mind too, and I meant to ask a witness, so I'll ask you, and if you want to put it in writing, and that is the listening service that's been set up. So that's a third avenue, isn't it, for survivors to go. One of the strong lessons we've learned is the pain and difficult, well, just the endurance that survivors have to go through and repeating their story over and over again to different places. And so certainly if there's a way of refining that down and meaning that the survivors only have to tell their story the minimum number of times. So that listening service is also important.
And that was actually one of the some of the feedback that came back from the HRC claimants, and in the redress program, it says that you can effectively make your application by using materials you've given in another context, such as your police statement or something like that. So,
or a private session with this commission.
So it's not necessary that you have to sit there and say, re-give that whole statement again to them. So that's expressed.
Thank you.
That's expressly dealt with in the terms and conditions, but I'll put that on my note. The next question I just wanted to briefly address is just, there was a comment made about the fact that the redress program relates only to old boys, and I just thought I'd give some background to why that is. You know, one of the great strengths of Dilworth is that it operates under this trust structure, which gives it tremendous freedom that is probably not shared by many other educational institutions, but it does impose some restrictions, and that ultimately the trustees are trustees in law and equity and have to follow the rules of a trustee. And one of the difficulties is that the trust is established, the trust is established to establish a school, but it then has an express power to help old boys who have left the school. And that's really been the source of power for the redress program itself. But unfortunately, it is a power that's limited to old boys, which is the where that restriction has come from. It's really a trust-based restriction. And that, again, that probably distinguishes Dilworth from other entities because they don't have absolute freedom. They've got a lot of freedom, but the hard limits they have are hard limits.
Yes. It's an interesting point. I mean, obviously the trustee, there must be some sort of third-party liability, though. I mean, I'm just thinking, if a burglar came on the property and injured them, so I don't know. Think about it.
Yes, it is a difficult issue.
It's a difficult issue, but you can see, can't you, just from the problem of one man, one survivor, who literally fell through the cracks and mercifully has been saved, well, picked up by the Anglicans, but not all will possibly be in that boat. So I think it is something that's worth looking at. Yes. Thank you.
There's a criticism made about by Mr. Firth about not seeking to correct statements in public. I'm not sure it's something that needs to be responded to by Dilworth, because I think it would be pretty obvious as to why that is not appropriate. But just to emphasise that Dilworth's very strong view is that it's not appropriate to challenge these experiences that are expressed in the press and other processes. The survivors are entitled to share their experience in whichever way they like, and it's not Dilworth's job to come in and try and criticise that or otherwise. There are forums such as the inquiry where these things can be investigated more deeply, but it's very much not Dilworth's attitude to these matters. And the final point was just a point about the consultation process, and Commissioner Olofuvai said, asked a question about how that consultation worked. Just in broad terms, as covered in Mr. Snodgrass's statement, there was the initial period of about some 4 months where there was a lot of dialogue with primarily the class action group. But then that led to a public consultation where there was a substantial website set up with Q&As and information about the program and interactive questionnaires that you could fill in and so on and so forth. One of the things I might try and get for you is we tried for Mr. Snodgrass's statement get the actual website links, but they've all been destroyed or replaced, with the new updated redress program. So that information was sent through to the Commission at the time, but unfortunately we can't recreate it at the moment, so I might see if I can do that just so you can get a feeling as to what the process for consultation was, because it was quite extensive on that aspect. But unless the Commissioner's had any questions or areas that you would like me to come back to you on.
Nothing. All right. Thank you very much, Mr. Barker. Thank you for your appearance at the hearing and for representing the Dilworth Trust Board. We very much appreciate your efforts and your team, obviously, behind you.
Thank you.
Thank you.